138.3 and 138.10 were conducted. One of the allegations that has been made is the chairman unilaterally tallied, verified, and declared the results of the presidential elections, that there was a requirement for a complete corporate process of internal tallying and approval by the commissioners, and that the chairperson can only act with the concurrence of the commissioners. Now, it's my submission that the reason why these submissions are being made is based on a confusion that stems from a misunderstanding of the nature and character of the commission and the interplay between the commission, the functions bestowed on the commission, and those cast upon the chairman of the commission. So first of all, the question that comes up is, who is the commission? And my learned friend, Senior, has alluded to it briefly, but let me just make this distinction because it is important. The commission, IEBC commission, is established like all the other independent commissions under the provisions of Article 250 of the Constitution. But more importantly, and this is the distinction that I think is important to draw, if you look at what Article 250 talks about, 251 says each commission shall consist of at least 3 but not more than 9 members. The next one says the chairperson and each member of a commission, so that these commissioners are members of the commission, they are not the commission. So that where the law refers to the commission, it is not referring to the commissioners, but it is referring to the body corporate that my learned senior referred to, and which is established or under the provisions of Article 253 of the Constitution, which says that each commission is a body corporate with perpetual succession and a seal. So where in Article 138 reference is made to the commission, it is that body corporate that is referred to. And this is amplified by the provisions of sections 11 of the IEBC Act. My lords and my ladies, section 11.2 of the Act establishes the Secretariat and the Commission, so that the Commission consists of the commissioners, the chairman and the commissioners, and the Secretariat. Then 11.2a defines who the Secretariat is as such professional, technical, and administrative officers and support staff as may be appointed by the Commission in the discharge of its functions under this Act. And B, very critical also, such public officers as may be seconded to the Commission upon its request. This is what comprises the Commission. And then, what is the role that the commissioners are supposed to play? Well, Section 11A of the IEBC Act then says that the chairperson and members of the commission, again members of the commission, shall perform their functions in accordance with the Constitution, and in particular, shall be responsible for the formulation of policy and strategy of the commission and oversight. Those are the 3 roles that are specified in the statute: provide or formulate policy, strategy, and oversight. That is the role that they play. Then the Secretariat shall perform the day-to-day administrative functions of the Commission and implement the policies and strategies formulated by the Commission. So this then brings me to the provisions of Article 138, 3C, which is at play in these petitions. And it's important, my lords and my ladies, to read what the provisions of that section say. And the reason why I go straight to that provision is because the petitioners are using that provision to say that the provision requires the commissioners to be involved in the process of tallying, verifying, and declaration of the results. But what 138.3c says is that in a presidential election, after counting the votes, these are the words they leave out, after counting the votes in the polling stations. This is about the polling stations. In the polling station, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. So this section refers to what happens at the polling station. My lords and my ladies, there are over 40,000 polling stations in Kenya. It is not conceivable that the 7 commissioners, including the chairman, would be the one to conduct the business of tallying, verifying the results, the votes at the polling station. This activity, as has been acknowledged by the courts in many cases, is undertaken by the officers of the commission in those areas. Indeed, in the first petition in Raila Odinga 2017, Lords, the court at paragraph 287 says, the duty to verify in Article 138, which I've just referred to, is placed squarely upon the Independent Electoral and Boundaries Commission, which was the first respondent. It is exercised by the various agents or officers of the first respondent. That is to say, the presiding officer at a polling station, the returning officer at the constituency level, and the chair at the National Tallying Center. No reference here to members of the commission. And this is very deliberate. The process of conducting an election is a statutory process. It is set out in statute. It is not an issue that is left to determination by the commissioners in a meeting of plenary as they have suggested. And so, my lords, the assumption by the petitioners that the commission refers to the commission is wrong and belies the case that has been brought before you. And so, my lords, the next issue that I want to deal with is the question of the role of the commission versus the role of the chairperson. My lords, under Article 138(3)(c), as I've said, the role of the commission, not the commissioners, is just to tally and verify the results. Sorry, and what is important here is this. My lords, and to respond maybe to my learned senior Jan Mohammed, the results of the vote at the polling station are made on the same day. The decision as to who members or the electorate will elect is made at the polling station, and the outcome of the voting is determined on the same day. It is filled in Form 34A. It is pasted on the doors of each and every polling station. Now, the important thing here is that there is not a single affidavit or evidence that has been placed before you by anybody who says that the results that were pasted on the doors of every polling station, the Form 34A, is different from the ones that were announced or declared by the chairperson at the National Tallying Center. And this brings us to what the courts have said consistently, that the results as announced by the by the presiding officers at the polling stations are final. Once those results have been declared, the voter knows that in my polling station, which had a maximum of 700 voters, the outcome of that vote was this candidate A got so many votes, candidate B got so many votes, and so on. So the result is known after the close of voting, when the counts are tallied by the presiding officers. And then, my lords, there is Article 138(10), which places an obligation on the chairperson to, within 7 days after the presidential election, to declare the result of the election. Now, my lords and my ladies, there is nothing strange about the provisions of Article 138(10). Declaration of the result, as was held in the Joho case, declaration of result is done in 3 stages. The first declaration is done at the polling station. If the argument by the commissioners was correct that the declaration requires to be approved, it would then mean that even the result that is declared at the polling station would require the consent of the commissioners. It would mean that the results declared at the constituency tallying center would require the consent or approval of the commissioners. It would mean that the results declared at the county tallying center would require the participation consent of the commissioners. That would introduce what this court has been avoiding all along, which is human interference with the process of tallying, verifying, and declaring results. And now I'll just discuss a few cases that show why these considerations are important, and I'll start with the case of Maina Kiai. My lords, in that case, the court stated that, sorry, my lord, let me start with the Raila Odinga versus IEBC, the 2017 decision. At paragraph 287, it says, the duty to verify in Article 138 is squarely placed upon the IEBC, and that this duty runs all the way from the polling station to the constituency level and finally to the National Tallying Center. There is no disjuncture in the performance of the duty to verify. It's exercised by various agents, that is to say the presiding officer at the polling station, the returning officer at the constituency level, and the chair at the National Tallying Center. Nowhere in that decision do you hear reference to members of the commission. It refers to specific officers whose duty it is to verify and declare the results. And why is this critical? At paragraph 288, this court explains why this is important. And it says the simultaneous electronic transmission, and my learned friend will talk about the electronic transmission. Paragraph 288, the verification process at all these levels is elaborately provided for in the Election Act and regulations. I will jump up to the part which starts by saying, but this electronic transmission also acts an insurance against potential electoral fraud by eliminating human intervention, intermeddling in the results tallying chain. Now you are being told that the commissioners need to be involved in the process of verifying and declaration of the result. This introduces exactly what the court said. We do not want human intervention or intermeddling in the chain of result declaration. And this ensures that there is no variance between the declared results and the transmitted ones. Now, the chair, again, plays a critical role in this whole process. In paragraph 365 of the same judgment, this court said that the chair has the duty of receiving the Form 34A as received from the constituency returning officers by signing the taking over section of Form 34B. It is his duty to do so. And then, my lords and my ladies, I deal with the issue that was raised that said that the chairperson styled himself to be the returning officer in respect of the presidential elections, and the suggestion that was made is that this title does not exist. First, my lords and my ladies, this is, it's wrong. That's not the correct position. The chairperson undertakes the role of declaring results, which is a role that you'll find under the under the Elections Act, is a role reserved for a returning officer. But just to lay this whole issue to rest, my lords and my ladies, in the case of Raila Odinga versus the Law Society of Kenya, this is the first Raila Odinga 1, 2017, at paragraph 8, this is what this court said. It says, the second respondent, who is the chairperson, Independent Electoral and Boundaries Commission, that's the second respondent. The second respondent, comma, the chairperson of the IEBC, who is the returning officer for the presidential election. Even this court recognized that is the role he plays. So it is not himself who styled himself. Even this court recognized that role and says it's constitutionally mandated under Article 138(10) of the Constitution of Kenya to declare the result of the presidential election and deliver a written notification of the result to the Chief Justice and the incumbent president. So that the role of the chairperson in the declaration of the results is recognized both under the Constitution, Article 138(10), but this court also specified that in playing that role, essentially what he's doing, he's playing the role of a returning officer. But this was even emphasized further in the clarification decision that was rendered by this court in 2017. And at paragraph 61 of the majority, the decision by the majority, the court said that at paragraph 61, it says that the, it It's a long sentence, but my lords and my ladies, I just want to read what is critical. It says the constituency returning officer aggregates Form 34A from the polling station into Form 34B before generating Form 34B. Doesn't the returning officer verify the figures in Form 34A? Is it not a fact that the second respondent, as the national returning officer, so that even in the clarification, when we came back to court and sought clarification, this court confirmed that in fact this gentleman is the returning officer, national returning officer, for purposes of the presidential election. And so the issue of him styling himself, my lords, does not arise. And it just shows you the levels to which the chairman has been unfairly vilified in a situation where the law is quite clear in the conduct of, on how he should conduct his affairs. The other thing that was also clarified a lot, my lords, and I'm just referring to this because there's no need for me to argue this, if the authorities already say so, is that the chairperson, the verification that is referred to in Article 138, 3C, this court said that the verification that is undertaken by the commission employees, by the people that we saw in the rotunda, in the tallying center, it says the first respondent on behalf of the second respondent, commission employees on behalf of the chairperson, must verify the results against those in the transmitted Form 34A. So that the way the petitioners have put it is completely the other way around. They are suggesting that the chairperson is the one who undertakes activities on behalf of the commissioners. It's actually the other way around. It is the commission employees that undertake the verification process on behalf of the chairman to enable him declare the outcome of the results. Which takes me, my lords and my ladies, to the next issue that I want to cover, which is the declaration of the result a plenary decision? And the question that we must start with is, what is the decision that needed to be made at the National Tallying Center? What is the decision? And my lords, if you look at the architecture of Article 138 of the Constitution, and you look at the Elections Act, there is absolutely no decision that is supposed to be made at the National Tallying Center. None. The only thing that's supposed to be done is an arithmetic exercise, which is tallying, aggregating the results, verify that the form that has been brought by the constituency returning officers, Form 34A, the original, compares or is the same as that which was transmitted electronically. Then add up the numbers. And then the chairperson is supposed to determine whether the threshold in Article 138(4) has been met, which is, has the person met the 50% plus 1 threshold? It's a question of arithmetic, which the chairman must make. And lastly, make a declaration whether there is somebody who has been validly elected. Fill the forms, and that is the end. That is the end of the exercise. He then gives the Form 34D to the president-elect, and that brings to an end the election process in respect of the president. The other administrative steps of giving the certificate to the Chief Justice and to the President comes later. Now, no one here is saying that there is this particular Form 34A that is different from the ones that were received. In fact, as my learned senior correctly says, nobody is saying that the number that was declared by the chairman is wrong, because according to us, the numbers achieved by the president-elect is different because they have calculated it. The number achieved by the second was a different number because they have calculated it. Nobody is talking numbers here. All that they are saying is trying to challenge the process that went on at the National Tallying Center. But nobody is saying that any particular number is wrong. And so, my lords and my ladies, the suggestion that we should have a plenary conversation about the result would cause huge ramifications to this country. Because what would happen if, after the elections have been conducted and completed, commissioners, for whatever reason, take different positions and decide that they are not agreed on the declaration to be made, and that a declaration cannot be made until they all agreed? If that was what was intended by the Constitution, nothing would have been easier for Article 138(10) to have made reference to members of the Commission. It is deliberate that it only required the chairperson to declare the results. And in my humble view, my humble submission, is that the protection intended by Article 138(10) of the Constitution worked in these circumstances. We got a declaration made because it is the obligation of the chairman to make that declaration, and anybody unhappy with that declaration, the option available to them is to come to the court, and the court will determine the issue. The option cannot be that a number of the commissioners can decide we are the majority and we are going to walk away, and therefore there will be no declaration of a result. That is capturing the Constitution. It is ensuring that the Constitution is not able to ensure the establishment of a government in accordance with its provisions. It is the reason why that obligation is cast on one person and one person only. And it is unfair to vilify Chebukati for doing what the Constitution told him to do, that if you are satisfied that the threshold in Article 138(4) has been met, and if you are satisfied that there is somebody who has been elected to be president, you need to make that declaration. Just like the declaration is made at the polling station, constituency level, county level, and at the presidential level. Well, this then takes me to the question of, and I don't want to spend a lot of time here, I will just gloss through it. What is verifying and tallying? I don't think I need to define this. I think verifying, I've already said, is simply just comparing the transmitted, electronically transmitted Form 34A against the Form 34B, Form 34A original as brought by the returning officer from the constituencies against the ones which have been transmitted. That's the exercise that is called verification. Tallying is aggregating, it's adding up the numbers just to make sure that that has been done. And this exercise was carried out. And we'll show you by the videos that will be played that in fact, the members of the commission, the commissioners, were involved in the exercise that was being undertaken at the National Tallying Center. Now, my lords and my ladies, you are also referred to extensively to the regulations and to the Gazette notice. So let me say this first. This is the first time, my lords and my ladies, that I hear a person being criticized for being too open. The chairman informed the purpose of a Gazette notice to inform the general public. The chairman informed the general public that he is the returning officer for purposes of the presidential election. He didn't need to do it, yes, but he did it. And he is being criticized for that very act of informing the public that of this fact. Secondly, they are now saying that because of the forms being in the public portal, it was possible for those forms to be interfered with in some way, and we'll show that there was no such interference. But the criticism now is, you are too transparent. You are just showing people things. Even your numbers, you are showing them. That is the complaint. And my lords and my ladies, this court has gone to great lengths to say that under Article 10, transparency is an essential ingredient of governance. So when you are being transparent by providing information, how can you be vilified for that? My lords, the chairperson is also criticized for setting out the result path at the National Tallying Center. He is telling the public, this is how we'll carry out the function of tallying and verifying. How can that be a source of criticism? Nobody is saying that there's a promise you made in the result path that was not followed. And my lords and my ladies, it's a humble submission that the process that was followed at the National Tallying Center, which is set out in the Gazette notice that I do not need to read out to you, was transparent, was verifiable, and was in accordance with the provisions of the Constitution. None of the agents that were involved and that signed the Form 34A has denied that they signed it. Nobody has come to challenge any particular document saying that it is not their document. And an interesting question was asked yesterday. How was a handwritten document to have been changed? In fact, by having it handwritten, it helps in ensuring that if there is any alteration, this is something that can be easily seen, because you can't change somebody's handwriting. And my lords, as I leave this point, it is also important to note that the agents of the presidential candidates, all of them, all four presidential candidates, their agents were at the National Tallying Center on the day. All of them. They participated in the process of tallying and verification. None of them has sworn an affidavit saying any of the numbers that were being, or the exercise that was being undertaken was wrong. None of them has picked a document, and they were allowed to take copies of all the documents. They were allowed to take images. None of them has complained about that process. Then we go to the issue of the 27 constituencies, and this makes me feel very sad, because, my lords and my ladies, as this process was going on the 15th of August, at about 3 o'clock, the whole exercise of tallying and verifying had been completed, and that is in the affidavit of Marjan and Professor Gulie. Members of certain political parties decided that it was time to stop a process that had already started. We all watched in horror on TV as members, some of them who were in this court, confronted the chairperson, threw down the pulpit where he was to announce the results, threw down chairs, assaulted the chairperson and the commissioners. In fact, Professor Gulie, the chairperson, and the CEO were injured. And we have attached documents showing the injuries that they sustained. And the intention was to stop the declaration from being made. Now, this is critical, my lords. Everybody has said why it is important that a government should not be established by means other than those set out in the Constitution. But equally, nobody should stop the process of the Constitution that result in the establishment of a government in accordance with its provisions. Stopping that process is equivalent to preventing the Constitution from being effected. It's a transgression against the Constitution. And it cannot fall from the lips of those people who tried to stop that process to come before you and say, the results of 27 constituents were not publicly announced, and yet you are the one who precipitated a situation where there was disorder, there was chaos. And this chairperson and the members of the commissions were now in fear for their lives. How do you tell them to still turn up and come and undertake an act that you have prevented from happening? And my lords, in the second petition filed in 2017, and my lords, at this time also remember, this is a time when one of the officers of the commission one had been abducted, the other one had disappeared and feared to be dead and turned out to have been murdered in any event. This is the situation that was prevailing at that time. My lords, faced with this situation, this court in 2017 in the repeat election was categorical that you cannot foment trouble, you cannot foment chaos, and then try to use the chaos as your reason, or the non-performance of an act because of the chaos, as the reason to come before this court for relief. My lords, it is critical that it becomes clear to political leaders that the decision as to who will be the leader of this country is made at the polling station. The agents, the commission agents who declare the results are just doing their job. If there is a problem, if the numbers of the votes that you got are not enough, the problem is not at the declaration. The problem is with the people who you did not persuade to vote for you in sufficient numbers. That is where the problem is. You cannot come to threaten members of the commission for purposes of them living in fear and refusing to do what they're required to do under the Constitution, and thereby enable you achieve a political purpose. And so, my lords and my ladies, the 27 constituencies, the critical point is, the results from those constituencies were tallied, were verified in accordance with the provisions of Article 138(3)(c). And you will notice that Article 138(3)(c) does not talk about announcing the results in the constituencies as a precursor or what will justify or validate the outcome. It doesn't. Lords, the next area that I just want to quickly go into, and I will just mention this in passing, the purposes for which we come to this court is that once they have made a decision, we don't revisit it. the question of the rejected votes, which I had been referred to yesterday, was determined in 2013. In 2017, Raila won, 2017, the issue again was raised. And this court said, with finality, that the only votes that will count are those votes that are valid. It's just valid votes. A vote that is rejected, a vote that is spoiled, does not express a choice, and therefore cannot count for anything. This court pronounced itself again in 2017. My lords, we cannot keep coming back before you and asking you the same question. You have answered it twice. I don't think I need to say more about it. The last item that I just want to deal with is the issue of constitutionality of certain regulations, which was raised by one of the parties. My lords, all I need to say about this, again, is that the provisions, these regulations were promulgated on 27th of April, 2017. They were the ones that were used for purposes of conduct of the 2017 election, first one, and of the repeat elections. No one has ever complained about those regulations. No application has ever been filed regarding the constitutionality of those regulations. In fact, when you retire to write your ruling, you will find that in both instances, this court relied on the provisions of Regulations 83 and Regulation 87 as the basis for the findings that were made, including the role of the chairman and the requirement for him to verify and tally the results of an election. And so, my lords, to now come late in the day, after you were made aware there is an election that is coming, you participated in those elections knowing that those regulations are there, and then when you do not succeed, you turn around and say, in fact, one of those regulations that were used is unconstitutional. That's one. Two, the law is clear, and I set out in the decisions that my ladies and my lords made in 2017 too, where you said that the determination as to constitutionality cannot affect antecedent acts. It can only look forward, so that even if there is a finding of unconstitutionality, and my humble view is that there is nothing unconstitutional about it, my lords, that cannot affect the election that was conducted on the basis of a law that was valid then. And so, my lords, it's my humble submission that this issue of whether or not the regulations are legal or not, my lord, is a small screen, because these parties, and especially the main petitioner, has been aware of this regulation and has participated in elections where this regulation has been used, now for the third time. The last item, my lords, is on the question of the postponement of the elections. Again, my lords, this has been explained in the affidavits that have been sworn by Mr. Gulia and also by the chairperson. And what happened is that the ballot boxes that were delivered, they had a mix-up in the names and the photos. And my lords and my ladies can imagine the confusion it would cause if this election was allowed to proceed on the basis of those ballots. Now, because of the deficiency of trust in this country, ballot pallets can only be opened on the eve of the elections to avoid a situation where IEBC is accused of having interfered or in any way manipulated the ballot papers. And so they were opened on the eve of the elections, which is on the 8th, and that is set out in the affidavit, when this mix-up was noticed. My lords, there was absolutely no time for fresh ballots to have been printed and delivered in time for the elections to be held. And therefore, in pursuant to the provisions of Section 55B of the Elections Elections Act, IEBC considered that this issue was an emergency. And what is an emergency? An emergency is an unexpected issue that requires immediate action. That's what an emergency is. And this was an issue that arose on the eve of the elections. These ballot papers could not possibly have been given to the electorate and told to use them for purposes of the election. And it is for that reason that IEBC, for purposes of securing the rights under Article 38 of the Constitution, decided to postpone the election to give the electors the opportunity to use the proper ballot papers for purposes of this election. And the mix-up was admitted by the printer. And what the printer did is that they agreed to print those ballot papers afresh at no cost. Now, my lords and my ladies, if we had used those ballot papers, obviously, we could not have been able to get a reprint at no cost. And secondly, for sure there would have been a petition on the basis that there was confusion arising from the mix-up in the images and the names. And so the postponement of these elections was justified in the circumstances. My learned friends dwelt at length on what the chairperson is alleged to have said in a public statement. My lords, these are newspaper reports that are given from time to time. And the important thing is, what does the law say in situations such as this? Does the IEBC have the power to postpone the elections? And the answer is yes, because it secures and protects Article 38 rights. My lord, the second issue that, and this is the court will take judicial notice of this, is that there was ongoing litigation in Mombasa regarding the gubernatorial seat. And this litigation went on up to close just before the elections were concluded. And so, my lords, again, this caused delay in terms of the timing of when those ballot papers would arrive. So, my lords, importantly, before the ballot papers were brought, the commissioners that are complaining all traveled to Greece. All 4 of them traveled to Greece to review and see how the printing was going on. They were the ones who represented the commission in Greece. And so, my lords, for them to now say that there was no, that this was an error, it cannot come from their lips. They were there, my lords. So it's a humble submission that based on what we have submitted, that the elections were conducted in accordance with the provisions of Article 138 of the Constitution, and that these petitions should be dismissed with costs. That's all, my lords.
May it please you, my ladies and my lords. For the record, my name is Eric Gumbo. I will be addressing the first, second, and third issue in the list of issues that were framed by the court. My ladies and my lords, I will, in addressing you on those issues, rely on the affidavits of Michael Ohuma, dated the 26th of August 2022, and rely on the affidavit of one Martin Wachira Nyaga, dated the 27th of August 2022, and the affidavit of Hilda Kavonga, sworn on the 27th of July 2022. So coming to the first issue, which is whether the technology deployed by the IEBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results, I will take a few moments to demonstrate how the technology that was deployed in the just concluded elections then met those constitutional imperatives. As a starting point, my ladies and my lords, we may want to ask ourselves, what exactly is this technology that we are talking about? And in answering that question, perhaps a bit of context would be of help. In the period just before the 2007 elections, when we still were dealing with the defunct Electoral Commission of Kenya, the legislative provision then, the equivalent to our Section 44, was worded in very loose, perhaps permissive terms. It was that to the effect that the Electoral Commission shall use technology where applicable or as may be appropriate. After the 2007 elections, we had the Kriegler recommendations, which then, one of which was that we must employ, or we should employ the use of technology in our elections. When we got to the 2013 general elections, there was a good attempt at using technology, but the various forms of technology that were used were not, were in different platforms, so that there was a different platform for purposes of registration, a different platform for purposes of identification, and a different platform for purposes of transmission. That did not work very well, perhaps because of the inefficiency attendant to the system then. Came the amendments in 2011 to Section 44, which required then that the technology to be employed was one to be integrated, meaning that in that one solution, we had the option for voter registration, which is biometrics. The second was electronic identification of voters and electronic transmission of results. Now, the question that we have before you today is whether, as conceptualized, that solution then meets the constitutional imperatives under Article 86 of integrity, verifiability, security, transparency, and accuracy. I will take a moment to just demonstrate how each of these would have been achieved. But when you retire, though, to consider the decision, I would invite your attention to specifically the affidavit of Michael Ohuma, who sets out in a very granular sense how these imperatives were met. I then would want to talk, that is specifically paragraph 39 to 49 of the affidavit of Michael Ohuma. I then would want to talk a bit to the process entailed in those three items. And I'm sure we are most of us are familiar, those of us who have participated in elections are familiar with that process. That once the voting has been done and the polling station has been converted for to the evening now for purposes of tallying and counting of results, we start by the counting in a very transparent manner. The presiding officers count each and every ballot, and I'm sure we've witnessed this, showing a vote for Gumbo, a vote for so-and-so, and a vote for so-and-so. Now, at the end of that process, they are then tabulated to give us Form 34A. How then is technology infused in Form 34A? Form 34A has internally identified security features. There are 8 in number. We have watermarks, we have UV potentials, we have microtext, amongst other security features. What is the significance of this? It is so that when somebody looks at the Form 34A, the original, it cannot then be confused for any other form, and that whatever it is that happened at the polling station remains an authentic representation of the will of the people. What then happens is that after that form has been tabulated, it is captured with a KIMS device. One copy is sent to the National Tallying Center. Another of that image is sent to the Constituency Tallying Center. And the presiding officer then collects all the, takes the Form 34A for purposes of the collation to the Constituency Tallying Center. That, again, is to achieve the constitutional imperative of verification. When we get to the Constituency Tallying Center, the returning officer has a back-end access to be able to load their Form 34B and transmit it to the National Tallying Center. Once that is done, they will then go with their Form 34A, together with their Bs, to the National Tallying Center for purposes of the verification and tallying at the National Tallying Center. Again, it is important to note that by the time the returning officer gets to the National Tallying Center, we have the image that is already in the portal. When they get there with their original form, an opportunity is then presented again for verification, for confirmation of accuracy, and more importantly, that in this election, because of the decision that was rendered by this court in the Raila Odinga decision in 2017, the Commission, in reconceptualizing or reconfiguring its electoral architecture, gave a public portal for people to be able to also follow, thereby meeting the constitutional imperative of transparency. It then meant that if I'd gotten my results from my village, my primary school in Member, where I vote, I would be able to follow those results all the way to Nairobi and take account and follow if at all there is anything that would have happened or changed. Then I must be the first person to be able to raise that concern. It should also not be lost that in that polling station, we have our agents, we have our observers. Again, to add to the fact of verifiability. So that then is the architecture of what our election pathway looks like. That said, it then must follow that at the polling station, if I am a candidate, I certainly must have interest in the outcome in that particular polling station. Because a copy of the results from the polling station would be given to me, I then should be able to communicate with my team, perhaps my national agent for a particular candidate, a particular party, to be able to demonstrate that what we got in Member Primary School and what has been transmitted to the National Tallying Center is one and the same. And that in the event that there's a discrepancy, it does not take magic to be able to point out that. Now, as to whether this technology was successful, Michael Ohuma deposed in his affidavit that 46,201 KIMS kits deployed throughout the Republic worked out of the 46,229. It then leaves us just with about 200 KIMS kits, which did not work at the opening or start of election on that particular day. I asked myself, if out of 46,000 KIMS kits, only 200 do not work, would I say I've failed? Even in our educational system, an A does not connote 100%. It starts somewhere from 88% going all the way to 100%. The mathematical representation of this gives us more than 99% success rate. In our view, that then achieved the constitutional imperatives that are contemplated under Article 86. Again, for purposes of confirming whether that system is secure, I invite you, my ladies and my lords, to look at paragraphs 51 to 63 of the affidavit of Michael Ohuma. Again, just to mention a few items in relation to that, that KIMS gadget works in specific ways. It is first locked to a specific polling station, meaning you can then not use it once you've locked it to the events of that day to transmit results from a different station for purposes of that election. That the entire network through which the results are transmitted are secured or double layered with firewalls, meaning there's a first firewall and the second firewall for purposes of securing that transmission. Very significant again to mention that at the point at which that image is to be transferred, it is encrypted. So as it is transmitted, it is not in the form of what we would imagine the image of Form 34A. If I was to use an example, if it was to be a water pipe and it is to be encrypted, it means if you broke into that water pipe, because we all know that the chemical formula of water is H2O, you'll get your hydrogen on one side, you'll get your oxygen on one side. It then means you'd not be able to make sense of that water that you're looking for. Again, we must be able to relate this with other factors. In the KIMS kit, we have certain information that is resident, close of business in any polling day. One of them is the question as to the voter turnout of a day. It means for somebody to intercept that system, they must have information in relation to the voter turnout of that day. It may not be practical for somebody to say that they have the capacity to know the voter turnout throughout the country at the second at which they want to intercept a particular form transmitted. Again, if we exceed the number of people who voted, then again, from an accountability perspective, it would be very easy to point out to say, because of the fact of this interference, you've exceeded the numbers of what was captured in your report. To give further comfort, this transmission is done over a virtual private network, which is provided by the mobile network operators, who themselves also secure that environment to ensure that there is no intrusion or interference coming from any quarter into the system. For a good, perhaps, mental understanding of what this means, or how this was applied, Michael Ohuma in his affidavit says that there were more than 380 million hits on trying to, just to access the public portal. And that according to him, none of the systems even blinked. That is how secure that environment is. Now, the other question that somebody would want to look at in relation to Article 86 is the compliance with the provisions, statutory provisions in relation to procurement and all those. Again, I invite you, my ladies and my lords, to look at paragraph 64 to 71 of the affidavit of Michael Ohuma. He then ends at saying that close of business, more than 14,239 people were successfully identified through that system. He describes it, to use his words, as a military-grade system. That is how comfortable he is with that, with the security features of that system. I come to the second question, which is whether there was interference with uploading and transmission of Forms 34A from the polling stations to the IEBC public portal. The emphatic answer is no. I have given a general description of the infrastructure that was laid out. I will take a few moments to demonstrate that it wasn't possible to get into that system, and that even if somebody attempted to get into the system, then it would have been noticeable, to again speak to the fact of verifiability, and that one would be able to pick that with pinpoint precision because of the manner in which the system works. For purposes of a clear understanding, it is purely because of that verifiability that we are able to hear our colleagues appearing on this other side for the petitioners saying that they saw a gentleman called so-and-so who accessed the system. So-and-so accessed the system because of verifiability. It means that those who were able to access the system must have been people who were then authenticated to access the system, because certainly you must get some human intervention if the system is to work. To this extent, we'll then invite you to look at the affidavit of Hilda Kavonga. Hilda Kavonga is the manager security and business continuity. Again, Hilda confirms emphatically that the system was not breached. She speaks at paragraph 7 in good detail about how robust that system was. I invite you, my ladies and my lords, to look at the structure of that infrastructure and just appreciate for yourselves how then it was secure for purposes of protecting the will of Kenyans. At paragraph 12, she even goes on to give security assurance through certification from the National Institute of Standards and Technology. Now, we look at this in relation to the allegations that have been made. There is an allegation about staging. Learned counsel, senior counsel, Philip Murgor, spoke about the man in the middle. The indication or the allegation appears to be that somebody intercepted the system or broke into this system, downloaded this form, altered this form, uploaded it again, and sent it or transmitted it to the National Tallying Center. Like I said, when eventually we have an opportunity to look at the details that we have submitted, including the KIMS returns, it will be apparent that there was no such intrusion. But assuming for one moment that we want to interrogate this fact of staging, we then would want to ask ourselves, at what point in time did this happen? Because according to the infrastructure that is laid out by the IEBC, once a form is transmitted from the polling station and it gets to the public portal, it also has certain inbuilt security components. It has a digital signature. That digital signature marks an indication as to the exact time when that form was transmitted. If there's intervention, then certainly there must be a lag between the time when that form was transmitted and the time the form got to the National Tallying Center. It is our submission that nothing has been presented before this court to even come close to making that suggestion. Again, as part of the security that is in the portal, each of the forms that get there are serialized. And the serialization is tied to the polling station. It is tied to the date, to the time, up to the second when that form was received. It then, as an additional property, gives you a tab to be able to confirm or verify whether there's been any alteration on the form from the time it was transmitted. One would then very easily pick up that as a concern to say, we refer you to, again using my primary school in Member Primary School, that the form 34A that was sent from Member Primary School was intercepted, manipulated at this point in time. That is a report that the portal would be able to generate. Again, not a single piece of evidence has been given to come close to suggesting this. I've pondered since the submissions and presentations yesterday from our learned friends appearing for the petitioners as to what really this evidence is. I have, in the course of struggling to look for this evidence, come across three possible areas they'll be talking about. In the affidavit of one John Mark Gidongo, they make reference to a form 34A from Baringo County, Tiati constituency. They then say that that is an example of a form that was intercepted. Michael Ohuma, in his affidavit, confirms that in fact the form that was uploaded or that was attached in the affidavit of John Mark Gidongo is not a form that arose from the process that, that they allude or allege it arose from. That according to him, this form was downloaded. Somebody tried to interfere with the details on it and attached it to an affidavit. Now that, if you asked me, is perhaps the silliest way of doing any of these things, because if somebody asked you whether that form was authentic, you only need to look at the public portal. You then need to verify it with the form 34A that was presented. My ladies and my lords, as a statutory requirement, we delivered all the form 34As to this court. We have a copy. The entire public has copies of each and every of those documents. Our team went through those documents, and in relation to that specific form 34A, to say the least, it's a forgery. The second attempt, again, by John Gidongo in his affidavit to try and present some form of evidence is in the form of logs, which were alleged to have been gotten somewhere. It says Karen, with these 56 mysterious people, and this, I think, is what senior counsel Professor Githu Muigai was talking about, hearsay on the back of hearsay. I was told that I had. Really, is that the sort of evidence that we want to present before this court? We took time, that is, the ICT team took time to study the logs that were presented. My ladies and my lords, I'm sure you have appropriate infrastructure to be able to make a determination on your own as to what these logs entail. From the analysis that were conducted, and this is again contained in the affidavit of Martin Nyaga, these logs arose potentially, or were picked potentially, from the 2017 general elections. Martin Nyaga, in his affidavit, identifies 9 obvious inconsistencies. I want to allude to just 2 or 3 of them. That, and that is in paragraph 13 of the affidavit of Martin Nyaga. If you look at the manner in which those those logs are structured, they serialized, in 2017, the IEBC serialized its logs using the names of the constituencies. In that particular log, you'll find a name Changamwe. This time round, they did not use the names of the constituencies. They used the serial numbers. So that is the first inconsistency. Looking at those logs again, you see the name of one Asenge running an IEBC email account. Asenge was one of the returning officers of the IEBC in Changamwe in 2017. One is then left to wonder, at what point do we get to even forging documents, forging logs, to be able to demonstrate our case? Perhaps I will get to that a little later. Enters the third piece of evidence, which was supposed to now clean what was presented by John Mark Gidongo, the affidavit by one Commissioner Justice Nyang'aya. Commissioner Justice Nyang'aya attaches logs to his affidavit. He then emphatically indicates that those logs go into confirming that specific named people accessed the system and that they then interfered with the results. He names 3 officers from the IEBC. Their details are in the affidavits. My ladies and my lords, again, we took time to run through those logs. The logs that were presented in the affidavit of Justice Nyang'aya, according to the information from the ICT team, and this is to be found in the affidavit of Hilda Kevongo, one, do not speak anything towards identifying any of those names that are contained in the affidavit of Commissioner Justice Nyang'aya. In fact, according to Hilda Kevongo, those logs speak to the ordinary applications that run the systems in IEBC on a day-to-day basis. If you read through them, because they're written in English, you'll find indications like daily update completed, news downloads for the day completed. At no point throughout the 7 or 8 pages, which is supposed to be a representation of the logs, does any of the names of these individuals feature. One then is left to wonder why such an inconsistency had to come in the manner in which it came. We have had allegations about certain named individuals. There's been an allegation about one Abdidahir Malim. My ladies, my lords, Abdidahir Malim was one of the returning officers, duly gazetted for purposes of this election. Like I earlier said, he then had access limited to the singular purpose of transmitting the Form 34B in relation to the area he was presiding over. That, therefore, is an authorized person. And indeed, Hilda goes on in her affidavit to confirm that all those other people who were mentioned were people who were duly authorized. There is the heavy weather that was made about the Venezuelans. A specific name has been dropped of one Gaidino Omar. My ladies and my lords, the contract between Smartmatic and IEBC was for the supply and maintenance of the infrastructure that they had. It then meant that they had to bring their personnel to manage or just monitor the smooth running of that system. Of significance is that Hilda, in her affidavit, then goes on to say that before the election, these people were all logged out of the system, and that on the date of the election, none of these people was in the system, even for purposes of that maintenance. My ladies and my lords, it would make a lot of sense if somebody said that so and so got into the system and they interfered with the system in this manner. It is not enough for somebody to say Gumbo was found in the system, because what matters here is the allegation around manipulation and alteration of the results. Now, if we do not get into this space, what exactly are we talking about? I would want to again equate this to a situation where in your house, you decide to assign a plumber to do for you some work. When the plumber comes to do the work, then you raise an alarm and say, oh wait, there's a plumber in my house. How is a plumber to do the work that he's supposed to be doing in the house? Certainly, it does not make much sense. If you expect the plumber to fix the plumbing problem, then certainly you must give him access to the plumbing problem that you have. Now, I have looked at, and we've tried perusing through all these documents. There is not a single form that has been presented which appears to suggest, even in the lightest of ways, that there was any interference. And again, just relating this to the architecture of our elections, if at all there was any such interference, it would have been an interference that goes into the numbers. Now, because we have not seen that, is this the case then, therefore, why numbers has become a very dicey and perhaps an area where everybody would want to avoid or run away from? In the petition, I suppose the first and most important thing is you must demonstrate that you had specific numbers. Even if there's to be contest, let it be contest between this set of numbers and the other set of numbers. It can't be a contest between the man who was said to be the man in the middle and numbers. If that man was in the middle for sure and he had a job to do, then that is a man who slept on his job. Because we are not shown anything that he perhaps could have done while in the space that he is alleged to have done anything that would have interfered with the will of the people. Hilda continues to wonder in her affidavit as to why their boss, who is a commissioner, would expose them to that extent that they mention names of people who are employees and staff of the institution doing their legitimate work. Then you cast aspersion without basis that they were engaged in a criminal enterprise. My ladies and my lords, it might sound like a light issue, but we must have seen it in social media, in mainstream media, that these people, some of whom ran this election, have had to go into keeping house. They've had to go into hiding because people read these sort of things and they imagine that this is the gospel truth. Certainly, this is not a light issue. Yesterday, there was extensive submission as to whether this court is handicapped in terms of dealing with some of these things. Now, as the IEBC, on the one hand, tries to improve the system based on the law and the guidance from this court, I think there's also a responsibility that should attach or follow where we have very deliberate attempts at misleading the court. If we look at, for instance, the logs that have been attached by John Mark Gidongo, if it turns out to be a forgery, does it not disclose an offense? It is not in my province to make that determination, but where I see it, it bothers me because as we go into elections this year, in 2027, we need to then sanitize some of these things that we do. And one of the ways of sanitizing them is by holding people to account, so that if you present evidence that is obviously not true or that is falsified, then you must stop to ask yourself whether there would be a consequence or not. That is the only way through which even this court would be able to sit, to be able to determine or preside over any of those matters that are presented with ease. I need to add that at the Bomas, which is the National Tallying Center, when the returning officers got to Bomas, what happened? Now, in the floor of Bomas, these returning officers would come with their original Form 34As, hand them to the national returning officer for purposes of a presidential election. After that, they would be subjected to an ICT team, and that ICT team was not sitting in isolation. They sat with the agents of the parties, they sat with observers, and what they were doing was to again confirm those security features we had spoken about. After that, they went into the detail around the numbers, comparing what they had in the Form 34As that were in the portal and the Form 34As that were then presented, the physical hard copies. From the direction and guidance of this court in 2017, Raila Odinga, what the commission was to do was to record those errors. I confirm, my ladies and my lords, that the commission did exactly that. The error report has been availed to this court, but of significance is that as they were preparing that error report, a copy of that error report was also availed to the agents of all the parties. This is important in the architecture of our elections. It is important because, as opposed to asking the court to now go through scrutiny, it will be a question of saying, wait a minute, in the error report, there's a difference between the results that came from Member Primary School, which I have either in my carbon copy from my agent, or that was presented by the returning officer, and what we are now seeing in the portal. That is the only way through which somebody could make an allegation that would stand the test of time. If you have that, then certainly, if you apply yourself to understand the architecture of our electoral platform, then there's really no need to go into scrutiny, because that report is scrutiny by itself. In fact, it was a forensic audit. They had their watermark readers, they had their UV light readers, and these are things that are all contained in the affidavits of these three individuals that I've spoken about. When you take time, you look at that, and it is then our submission that to the extent that there is an allegation that there were interferences or that there were differences between the Form 34As in the portal and the Form 34As physically presented by those returning officers, there was none, and this is verifiable. Indeed, none has been presented before you. The last issue I'm to deal with is whether there was a difference between Form 34As uploaded on the IEBC. Sorry, I think I'd gotten into that point as well. And so, there was a question that was raised about Form 34C and the concern about the multiple entries. Submission was made by counsel that the Form 34C is supposed to be generated once. Again, that sort of submission would only come from a false, if not limited, understanding of the process. I say that because as the verification and retallying of the Form 34As were going on at the National Tallying Center, whenever they completed the verification and retallying of a constituency, they would then upload it onto the Form 34C after the completion of the verification. That then meant that that process had to be an incremental process. That is why when somebody says that there is a gentleman called so-and-so who accessed the server or the rear end of the result transmission network 1,000 times, it simply speaks to the fact that they had to make entries. It should not be lost that we were using, according to the jurisprudence in Maina Kiai, results from the polling station, which is the original Form 34A. Now, if we look at the number of the polling stations, it speaks to about 46,000 and a few hundreds. It then meant that a corresponding number of entries had to be made on that Form 34C. And that, because I'd said it is supposed to be done incrementally, I would want to refer for clarity again to the affidavit of Commissioner Justice Nyang'aya. At paragraph 51 of the affidavit of Commissioner Justice Nyang'aya, he says, or he acknowledges, that indeed it would be inaccurate, impractical to expect the 7 commissioners to be the ones to do all these specific assignments that the commission is supposed to be doing. Similarly, and by parity of thought, when the law says that the commission shall, for purposes of this, generate that Form 34C, the law does not contemplate that the chairperson of a commission will sit with a laptop and make 46,000 plus entries by himself. This is what my learned senior counsel Kamau Karori was speaking to. This is what is contemplated under Section 11 and 11A of the IEBC Act. And so, if we then tie this to the submission that he had earlier on made, that if we read under Article 138(3)(c), the Independent Electoral Commission to mean the entire institution, then we would not run into the problems that we are running into. Because as we saw, and as will be demonstrated in, by our subsequent speakers, that exactly is what happened. The entire bureaucracy or the entire institution of IEBC participated in that process. As I conclude, I want to make a submission that when we make these allegations in our election petitions, perhaps we need to also ask ourselves if we have done that which the law contemplates of us. And that if the law gives you an opportunity to choose your agent for purposes of verifying or speaking to you in relation to the processes in the election, if you fail to present an agent, would it be appropriate to then come and burden the subsequent processes through applications such as what we're seeing for scrutiny, because the law contemplates that that agent should be able to point you to the fact there's a problem in a particular primary school. Go there. Don't ask for the entire of a constituency. Don't ask for the entire of a county. And I think that has been the jurisprudence that has been developed. It then follows that we must sanctify the place of agents in our elections. And because agents are like our spouses, you choose your own. You choose the one you trust. If you get, nobody imposes an agent on you. If you choose one you don't trust, then really you can't blame anyone. If you choose one who does not understand why you assigned them that responsibility, again, you cannot possibly blame anyone. So, as I seek to take my seat, we ask, my ladies and my lords, that in the usual strong manner in which you've spoken in relation to these issues, and following the very lengthy submissions that we had yesterday, we also rely on you to help us clean this electoral system, so that as the Commission does its part, on the other hand, the public and every other person must also do their part. I am most obliged, and thank you for according me this opportunity.
My Lady, the Chief Justice, the Deputy Chief Justice, and the members of the Supreme Court, it's indeed a great honor to appear before you in relation to this petition. My role today here is to take you through the numbers. I will take you through the numbers. The numbers will be running on the screen.
Your name, please.
My name is Mahar Somane Advocate. My name is Mahar Somane Advocate. I'll take you through the numbers as it relates to the petition that has been filed. I will also give you an audit trail of mechanism which the court can use to measure the petition. The first question that I'll answer today relates to the question that has been put to us. And the first one is whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui Rural, Kachaliba, Rongai, and Pokot South constituencies, and electoral wards in Nyaki West, in North Imenti, and Kwanjenga in Embakasi resulted in voter suppression. The allegation of voter suppression due to postponement of these elections is not a question of hypothesis. It's a question of fact. It's a question of numbers. What I have done is we have gone through the numbers to give you a comparative data on whether the same is true. The first one, as it relates to Kitui Rural, we have gotten the data for the constituencies in Kitui. Your Ladyship, if you look at the constituencies for Kitui, the voter turnout for Kitui Rural was 60.29%. So for us to actually make a comparative data and analysis to actually see whether there's been voter suppression, we look at the constituencies nearby and see the data we are getting from the constituencies nearby, whether the inference can be made by this court that there has been voter suppression. The voter turnout for Kitui Rural is 60.29%. I have highlighted in yellow in your screens. It is comparatively similar to the voter turnout in Kitui Central. In fact, it is Kitui Rural is higher. Kitui Central is 60.10. It's comparative to Mwingi Central. So to the question the court asked, whether there was voter suppression in Kitui Central constituency because of the postponed election, the answer is an emphatic no. I will go to the second question. The second question the court asked is whether the postponement of elections in Kachaliba and Pokot South led to a voter suppression that led to low voter turnout in favor of the petitioner. The answer is data-based. I have provided the comparative analysis. I want the court to look at it. The voter turnout for West Pokot was 81.44. The voter turnout for Kachaliba was 81.44. I have highlighted in yellow. The voter turnout for Pokot South is 80.44. it is higher than Kapenguria, it is higher than Sigor. Comparatively, in fact, those voter turnouts were higher than the ones which the elections were not proposed. That claim falls flat on the data that were provided to court. I will proceed. I will go to Rongai. The question the court asks is whether the postponed elections in Rongai led to suppression of voter. I have provided the data on Rongai. The voter turnout of Rongai was 61.41 for the presidential. It is higher than in Joro. It is higher than in Naivasha. And it's comparatively similar to the other similar constituencies. To the allegation that there was voter suppression in those places because of the election that was postponed, that allegation is untrue, falls flat on the data we have provided. To the other question, whether the postponed elections in the MCA ward for Nyaki West led to voter suppression, the voter turnout for Nyaki West was 64.32. If you look at North Imenti, it was even lower. It's comparatively similar to the other we have provided. To that allegation, that falls flat on the data and the comparative data we have provided. To the allegation that the MCA ward in Kwanjenga, that there was voter suppression because of that, the MCA ward in Kwanjenga, the voter turnout was 46.32, comparatively similar to Embakasi South, which is 49.62, comparatively similar to Imara Daima and also in Pipeline. To that allegation, when you look at the comparative data, it's not a matter of hypothesis, it is not borne out by the data. To the allegation that the postponed elections in Kakamega led to voter suppression in terms of the petitioners' votes being undercast, the allegation falls flat on the comparative data. We have provided the data for Vihiga, which is similar. Bungoma was a bit higher, but Vihiga is the same. So comparatively, when you look at those data points, that allegation falls flat. To the allegation that in Mombasa, there was a voter suppression because of the election that was run, I want to point out, even in 2017, the general voter turnout in Mombasa is generally very low. That data is available. It's always lower than the other constituencies. But comparatively, it is almost something that is comparable. To those, so I have answered. So to the question that the court put out on the comparative data, the answer is there was no voter suppression in those places. Senior Counsel Kamau Karori has already explained on the reasons why those elections was not held. There was nothing premeditated about those elections, not holding those elections. Reasons have been given in the affidavits of the chairman Wafula Chebukati and Marjan Hussein Marjan. So to that allegation, we want to show the court the petitioners have a hypothesis. We have provided the data to the court to actually aid the court to come to a conclusion. The second question I want to answer that the court put out to us was whether there are unexplainable discrepancies between the votes cast for the presidential candidates and other elective posts. Indeed, if there was unexplainable discrepancies, is a grave issue, which we know. We will show through the data that we have provided to the court that the same is not true. In fact, we can account for each ballot. To just guide the court, refer to the affidavit of Moses Ledama Sunkuli, which is on record. We have provided the comparative analysis. In fact, what I did is we provided the 34C, the 37C, 38C, and 39C. Those are the forms for the governor, the senator, and the women rep. We tallied against the presidential. I want to refer the court to paragraph 36 of Moses Ledama's affidavit for the court to look at it. And if you do a tally, and we started with a tally for Senate, if you do a tally for the votes that were cast for the Senate, vis-a-vis, and that, Your Ladyship, that runs from page 13 of Ledama's affidavit up to page 15. And I just did the summary analysis, but there's a very big comparative table that I've put out there. If you do the analysis, you will come to the following conclusion. What is the voter difference between the senator and the presidential? 500 votes, the variance. And how do we account for those variants? So when you do the presidential like for like and the senator, you will get a difference of 22,801. You have to minus diaspora voters, which only vote for the presidential. You have to minus prisons, which only vote in the presidential elections, okay? And then you have to look at stations which were affected and did not have any results for any of those elective posts. For example, in some of the stations, some few stations, some violence happened. Likely they did not report for Senate. When you do that analysis, you will get the differential is 500 votes. I have done an elaborate analysis also on the stray ballots. When we get to that, I will explain. So the differential between the Senate and the presidential is 500 votes. And that 500 votes, we can account for in stray ballots. I have attached the polling day diaries for Kibra and Makadara. I have done an analysis to actually check what is the stray ballot per constituency. And this tally is like for like. So to the question whether there was a discrepancy between the presidential and the Senate vote, the answer is an emphatic no. It is explainable by looking at what the information that we have provided. To the second question, whether there was a discrepancy between the women member of National Assembly for the women rep as compared to the presidential, I will tell the court to look at page 18, page 17 and 18 of Moses Ledama's affidavit. And our answer is there is no much difference, and the differences can be accounted for. The variance analysis we have provided. To the question whether there was a discrepancy between governor and presidential, we have also explained that there's no such variance. Petitioners have been talking of variance of 800,000, 900,000. There's no such variance. And in fact, the small variance that you will see for the women rep, which is 9,419, can be explained for by the stray ballots. A small analysis we did for the stray ballots, Your Lordship, is that in Kebra constituency alone, we did a stray ballot analysis, and it's shown there. So to explain, and this is how we understood the court to mean the duty of the IEBC is to explain each ballot cast and track that ballot to see where it has gone. So once we do the analysis for the presidential and we remove the prison voters, once we remove the people who voted for diaspora, once we removed some of the small polling stations that did not report for any of those seats, you will see a small variance. So we thought the court will ask where that small variance is coming from. And so what I did is we went and we went to sample one of the constituencies in Nairobi. And in one of the constituencies, Kibra constituency, we got 405 stray ballots. So you can't account for the way it will work is it will take from any of those ballots small incremental numbers. So you will see a variance of 500 here, 200 here, but cumulatively it is not something that cannot be explained. And I have attached all the polling day diaries. In fact, if you look at the Form 34A, which was supplied to the court, some of the comments section will indicate that they found some stray ballot in the presidential ballot. But to the court, whether there is discrepancy between the senatorial, governor, and the women rep seats as compared to the presidential, there is none. We have demonstrated that with data. And even when there's a small variance, we have shown the stray ballots that cumulatively over those 3 seats, that will be there. A question was, a submission was made by learned counsel Ms. Julie Soweto that there is 33 per polling station stray ballots in Kirinyaga. I will explain that. I don't know what numbers they are using. It's an old litigation strategy in numbers for shock and awe. I think what they are trying to, if you look at the numbers for Kirinyaga, there is no difference between presidential and the governor of 22,000. In fact, the variance is 900 votes, which can be explained for by the stray ballot. The number they have indicated for governor, I don't know where they have gotten it from, is not what is in our 37C, and we've indicated that in our submission and also in our presentation. So to the question that the court asked, that whether there are inexplainable discrepancies between the votes cast for presidential as against the governor, for presidential as against the women rep, for presidential as against the Senate, the same is not borne out by the data. that we have provided to the court. Now I'll go to another issue which was made heavy weather of by learned counsels on the voter turnout. Justice Smoking Wanjala asked, how important is the voter turnout to the actual valid votes and to the actual declarations? Of course, it's an important issue. The only problem with it is that counsel are not understanding how we calculate voter turnout. And I want to explain to the court how voter turnout calculation is done using the kits. Pursuant to the Maina Kiai case, the court was very emphatic that elections must be conducted at the polling stations. And pursuant to that, voter turnout reporting is done per polling station. So how do we do it? When the polling station opens and Kenyans are voting, depending on the network access of the kits will be sending us information every 2 hours. The kit will be telling us 200 people has passed by this kit in this polling station, and that information will be collated until the end of polling day. So 2 things to note here. The first one is that the reporting is done per KIMS, per polling station of the reporting KIMS. So for example, on the 9th August 2022, when the polls closed, the IEBC gave a turnout figure of 56.1679%, which is the percentage turnout. That correlated to the total number of registered voters in those schemes, in those polling stations. The problem that the petitioners are having, they are saying these 56.1679% you announced must be of the total people in the register, which is 22,140,258, 120,258. We don't do that. We report per KIMS. So if 200 people reported in that KIM and the number of registered voters is 600, we say 200 of 600 voters. We add the next KIM, 300 people have reported, we say 300 over 600 voters. The next KIM, 400 KIMs have reported, 400 over 600. We keep on aggregating until we see how many KIMs have reported of those polling stations. Why do we do that? Because of 2 reasons. The first one is, which is in the affidavit of Hussein Marjan and the affidavit of the chairman, because of network issues in some places, far-flung places in Kenya, some of those schemes will report late. Some of those schemes will report much later. So if we did a number over the total number of registered voters, we will be giving a false turnout. So the turnout we give is based on the aggregated voters of the reporting station in that KIM. So if you took when we announced, the 56.1679% is based on the total registered voters in those stations who have reported in those KIMs, which was 21,481,642. Your Ladyship, you'll realize this is much lower than the total number of registered voters. And we'll keep on accumulating. KIMs will keep on reporting. 235 polling stations went manual. We will have to later on aggregate the 235 polling stations which went manual. Then we come with a total voter turnout. And if that is the reporting we do, 2 arguments that have been made in the petition of Omtata and in the petition of number 5 fall off. The first one is, their contention is that the chairman announced a turnout on 10th August 2022. That is the third line, Your Ladyship and members of the court, announced a turnout of 65.4%. What we have indicated is 64.6%. Your Ladyship, I will pause there to just inform the court that the chairman clarified that statement. The recording is in the affidavit of the chairman. And the actual clarification the chairman gave, he said that the total reporting polling stations, and if you hear his statement, it will give some clarification. We never say the total number of registered voters, because we will have that information when our manual count and everything has reported. We say total number of polling stations reporting. So in those schemes. So they're saying 64.6% must be of the total registered voters. That is their contention. That is their voter turnout. That is not the voter turnout of IEBC. The voter turnout as a percentage was, at that point, 64.6%. The number of reporting KIMs were 21,926,565. You will notice from this number, there are some polling KIMs which haven't reported. As they go to the constituency tallying center, those KIMs will report. You will also notice that we haven't included the manual count to give us a total figure of the total voters who will have registered, who will have reported. On 10 August, when all the KIMs returns have come from all the polling stations, the number of persons identified, that is the last number on the table, 14,239,862. As against the total registered voters in those stations which reuse the KIMs, 22,005,541, giving a turnout of 64.7103. You notice, Your Ladyship, we haven't included the manual count. So that is all KIMs in all polling stations. What remains now? Manual count. And this is important. I will pause there. We were very deliberate in trying to help the court in be able to identify and actually provide an audit process for the contesting parties' allegations. In the affidavit of Michael Ohuma, we have attached 7 volumes of the KIMS returns for every polling stations in the Republic. Why is that important for the petitioners and the court? That is the first audit trail process. How is it at the first audit trail process of? We've provided the KIMS returns per polling stations in the Republic. We've also provided the certified copy of the 30A. So if anyone wanted to look at how many people passed in that polling station, you will look at your KIMS return, you will look at your 34A. And if there's any inconsistencies between the KIMS return and the 34A provided to the court, then question can be asked to our client. So in providing an audit trail process, the first way of providing an audit, which is both manual and electronic, is the KIMS return provided in the affidavit of Michael Ohuma in 7 volumes, as against the certified copy of 34A we provided as per the regulations of this court. So we provided that. And if you look at those KIMS returns, they will correspond with this. They are from 45,994 polling stations. The number identified by KIMS, 14,229,862. The total number of registered voters, 22,005,591. And the percentage is as indicated. We've indicated how many KIMs there were. And I just want and after the aggregation of the manual and the KIMs, and that's the table that's there. So to the question, I think that is important for the court, and the court will ask, is the first question that the court will ask, what is the registered voters in the Republic? And I think that is not contested. 22,120,458. I think it's in the affidavit of everyone, that the register is publicly available, that can be accessed. How many polling stations do we have in the Republic? 46,229. How many people are registered in those polling stations? 22,120,458. How many polling stations were authenticated through using the kits? 45,994. How many registered voters are those in those polling stations? 14,239,862. What are the registered voters in those polling stations authenticated through the kits? 22,005,591. What are the polling stations that were not authenticated through the kits? 235, out of which 6 polling stations, 3 in Eldas and 3 in Quisero, there was violence. And no voting took place, in fact, at the time of that. And so how many polling stations went manual? Using complementary system, 229. What are the number of voters authenticated through the complementary manual system? 86,889. What are the registered voters in those 235 polling stations? 114,917. Why are these numbers important? They are important for audit trail. First, we have provided the KIMS returns to the court, which can be compared as against. Secondly, 99.9914% of Kenyans were authenticated through the KIMS. Less than 0.001 Kenyans were authenticated through a complementary mechanism. And the reason why I go back to that is giving the court an integrity check as to what we did. So if we are telling the court that 99.99% of Kenyans were authenticated through the kits, we have provided the receipts from those kits to the court, we have provided the Form 34A, then the court can compare and will bear out the work we did. Another allegation falls off. So what is the allegation in the Umtata petition? And I will go back to the turnout table. Your Ladyship. They are saying that the turnout announced by the chairman on 10th August 2022 must be over the total registered voters. That is where the mysterious 140,000 is coming from. So they are saying the 64.60 must be from the 22,124,058. We are telling them that is not how we calculate our turnout. It was very easy to confirm with us and ask us how you do it. We're telling them that number is out of 21,926,565. We could not do it over the registered voters because some stations went manual, some KIMS had not reported. How will we give a number over a total in which we don't know the status of some of those stations? Because the returns have to come for us to be able to give that. So they're saying 64.6 over the total voter turnout will give you 140,000. IEBC has not accounted for 140,000 voters. It's a lie. I think they are wrong on the maths, and they are wrong on the substance, and they are wrong on the substratum of how we are calculating that. And I think it's imperative that the court understands that. So the issue of 140,000 is not here nor there, and we have demonstrated that. And the second issue is they say that there was 110 voters error, 110 error in the Form C. By virtue of that, the Form C is not a valid vote. We have acknowledged that error. It's a data entry error in 2 stations in Kilifi and 1 station in West Pokot. It is the error form for the C is attached to the chairman's affidavit of 110. The Form C is a collation of 46,229 polling stations, and there is an error of 110 in which we have explained the data entry. I think that is not something that is material to the Form C for the court to say that a Form C is invalid because of an error which you have acknowledged. Your Ladyship, we also want to confirm to the court, we have done an error report for each and every polling station in the Republic. And this is going to be, and we really are craving for the scrutiny report to bear, and this will bear us out. That the voters, what Kenyans voted on the 9th of August is what was transmitted, and it's what was actually announced by the chairman. The will of the Kenyan people was carried out through and through. And that will be borne on by the scrutiny of those ballot boxes. That will be borne out by the information and the data we have given. And that is really, really important. The other issue I want to actually address is allegations that have been, Your Ladyship, if I could just go to the affidavit of Mother, I mean, this is what I was talking to. I mean, there's an allegation of paragraph 96 of the affidavit of the petitioner that alleges there's a variance of 25,000 between governor and president. The correct position is there's a variance of 900. It's worth noting the county is home to 2 prisons. And this is what the court should, and we can provide the court with, even if the court is inclined to even order us to bring all the original Form 34As and the Cs. We are ready and willing to provide that to the court. Some of these allegations, when you look at it, you really cringe that the allegations that are being made on these numbers, they have no basis. You will actually wonder how will someone write something like that in the petition? We have provided a tally of our the C series for the governor, for the senator, and the women rep. And we're ready to provide that to the court. We have put that in our affidavit. We are ready to provide whatever the courts will require to actually prove some of those numbers that are being banded. And some of these numbers are just meant for awe and shock, because it is very shocking to the court, to the conscience of the court, if you are told there are 25,000 people who walked into the polling stations in Kirinyaga, voted for the presidential candidate and did not vote for anyone else. It's really amazing. I will expect a variance because of the small stray ballots here and there, or maybe the prisons and diaspora, but it will not be 25,000. It's something should be that is explainable. And that is why the petitioners are wrong on the data, they are wrong on the numbers. And I will also demonstrate they are very wrong on even the ICT. I will add on to what Judge Eric Gumbo had also submitted. There are 2 allegations that are being made that the Form 34A, and I want to explain this to the court. So we have 3 audit trails or 3 verification processes for the court. The first I mentioned, it's the EVI, the Electronic Voter Identification. We have given the KIMS return to the court. So the court will look at the KIMS returns and look at the AOL, the tally. The second one is when the Form 34A is being sent, and I've seen a lot of wild allegations being made, and I want to just explain this to the court. At the end of the polling, what happens is the kit, it converts itself into an RTS system, a result transmission system. The PO scans a QR code, it gives him a transition system. So it tells him, okay, Mr. PO, what do you want to transmit? Enter your PIN. He will enter his code. It gives him a query. You tell him, what do you want to do? He says, I want to transmit 34A. It tells him, okay, can you confirm the following checks have happened? And that's a validation check. Can you confirm that this form is signed by a PO? He says, yes. Can you confirm that this form is signed by a DRO, a deputy PO? He says, yes. Can you confirm this form is a 34A? He says, yes. Can you confirm this form has been signed by the agents? He says, yes. So after saying all that, then he tells him, take an image. And there's a lot of things being bandied here about the image. And we can provide, I think we've done training for the IEBC has done training for everyone, for LSK and the judges, and this is something that we can even provide if the kits are required. The kit takes an image, embedded in it, it has a scanner, and the image is embedded in the KIMS, so it's taking the image, and it's taking the image and scanning it as a PDF. We don't have any other output. We don't, and there's a reason why I'll explain to you why that input is being made, why it's like that for purposes of the security and the other purposes. He takes the image. It actually tells him if the image is not clear, it will tell him your image is not clear. Please retake it. So he takes his image and he presses send. That image travels from that, it is gone. He cannot recall. In fact, even if he does not have network, it will tell him the image has been sent, it will arrive when it will arrive. That image cannot be recalled in PDF. There's nothing that can be called. That scanned image in PDF, there's nothing that can be done about it. That is gone. When he gets network, or immediately if he has network, it will hit our portal. Now, When it hits our portal, it's something akin to someone who's coming in the Supreme Court. The Supreme Court is established by the Constitution, and it has the jurisdiction by the court is limited by the Constitution. So those forms answer some jurisdiction questions before they are admitted into the public portal. What are those questions? So they ask, okay, you have come here, you have come into the court. If you want to sit here inside the court, answer the following question. They ask, are you a 34A? He says, yes, I am a 34A. Okay, do you confirm that you come from the code of the polling station? So it has a code of the polling station. So it will run against the polling station codes, it will confirm. Then it is asked, okay, we've confirmed you are an A, we've confirmed that you are from the code of the polling station provided to us, because all our polling stations have specific codes. Then we ask them, then it's asked the third question, do you come from a serial number of our kit? Then he answers, yes, I am from the serial number of the kit. If it is another form which is coming, if it's not from a serial number, it checks, it tells, no, you can't come in here, you have no jurisdiction. So it tells, do you come from a serial number of our kit? He says, yes. Then it's asked, do you come from the SIM card that has been provided officially that we have the list for from the various providers? It answers yes. Then it's given two security features, which are very important for the court. So it's given two security features. It is given a date stamp. And I urge the court to interact with the public portal. I want to confirm to the court 800 million persons access our portal. It did not even blink for a second. Its security, its firewalls, and the SOC are military grade. And in fact, a lot of the allegations that are coming from the other side is, people are so frustrated in trying to hack our system is, why is your system so good? Our system is so good because it's based on blockchain. It actually, what it does, it actually gives resources as is required. If the 50 million Kenyans logged in now to our portal, it will give them, without even stuttering, whatever form they want. And it will allocate resources on how many people. Out of those 380 million people, 300 million were Kenyans who downloaded, who looked at the result. So after asking that, it gives two things. It gives a timestamp. The form is given a timestamp, and it's given a date stamp. Now, with that, one of the allegations of staging falls away. So someone is telling you, someone captured a form, amended it, returned it. I am telling you, all my forms have a date and timestamp to the millisecond. And there is no one form that has been transmitted at the same time. And in fact, if you look at the portal, you will see that. You open the portal, if you look at the tab of the portal, it will say 34A. It will tell you the polling station. It will tell you the KIM serial. It will tell you the date the form came. And how precise is this system? Some of those forms came on the date of the election. Some of the forms, because of tallying, came a day later. Some of them came 2 days later because of the elections in Eldas. And it will give you the timestamp to the millisecond. And actually, if you look at it, so if someone is telling you, oh, we had staging of 11,000 forms, you will expect that to the millisecond, right? To the millisecond, you will get 11,000 forms which have been uploaded. And I want to inform the court, there is no one who can upload the Form 34A. Form 34A are only transmitted from the KIMS by the PO. Neither Wafula Chebukati, nor Hussein Marjan, nor Boya Molu, nor anyone else can upload Form 34A. Form 34A is transmitted from the polling station, goes, and that is the end of that story. And once it goes, it asks those questions. Now, our forms are designed that way. Why? Some of the forms that have been brought to you, and with due tremendous respect, I spend a lot of time with my ICT people and look at some. Some of those forms are doctored forms. Why are they doctored? Because of the audit trail that will not allow anyone to be able to actually not be able to verify our forms. Why? So I told you about the EVID and the KIMS, returns plus the form. So these forms have 3 manual processes and 3 electronic processes that check each other. for the court, and this is very important for the court to actually assess those allegations. So what are the 3 manual processes? PO fills the forms, gives to the agent, paste it there, okay? Travel, so the first one, if you had an agent there, you will get your form, or it will be in the polling station, it will be stamped in the polling station. The second one is, okay, I didn't have a PO. What check do I have? So I will, both someone who did not have an agent and person who had. So if I didn't have an agent in the polling station, that form travels to the arrow. What does the arrow do with the form? His PO will sit there, he'll tell him, I have received the form in the portal, I want to confirm the form you have brought me is the same as the portal. Is it the same serial number? Is it from that KIMS kit? Does the tally agree with what is in the portal? He has a back end for his B, because he has to start populating his B. So he takes the form. So we allow at the Constituency Tallying Center to have agents. If you want, copies of the form can be given. So if you didn't have agent at the polling station, you can still get your form at the Constituency Tallying Center. So say you didn't have an agent at the Constituency Tallying Center, you didn't have an agent at the polling station. We bring the form out to the National Tallying Center. And I think this is the reason why this court made the decision that the chairman must verify each and every form. And court will take judicial notice of what was going on in Bomas. We had 14 verification desks. The arrow will come. I had the pleasure of actually going through the process. The arrow will come. He will be told, okay, you've come with your forms, sit. He will be admitted, and then the verification desk will have all the 4 agents for all the presidential candidates. We take the forms as they are. We make copies of the originals for them. Remember, they have their agents' forms. We make copies of the original. We tell them, okay, these are the copies of our original. Have your agent's forms, compare with our originals, but also what we are going to do is not a verification process. We'll do a forensic audit for you. We'll call the arrow. He will sit on the table there. He will go form by form. Is it the same serial number? Is it from that polling station? We provided microtext readers. We provided watermark readers of the originals. The agents are seated there. They will check, and they will look at it. And the form will have the IEBC. It will have the watermark reader. It will have everything. So even if you don't have the forms at the CTC and at the polling station, and you had the form at the constituency, and you are given the form as at the NTC, you could still verify and actually check. After that, they will go to an ICT desk. The ICT now will confirm whether those forms and what is in the portal is the same. And some of the persons who've sworn some of the affidavits in the petition were seated on those tables. The ICT will open up his portal. He say, oh, this is the public portal. I am looking at the form. Let's confirm what is in the form, what is in the portal. Do they tally? They tally. If there's any issue, we do an error report, which we have provided to the court. We have provided error report to them. That process is documented. And even if you didn't have all those agents, then you had an opportunity to do at the National Tallying Center. After that, we tell them, okay, we've started populating the C. Now, have you verified this polling station? Yes. Okay, now we put that into our C. And the idea that the C was kept on changing and some officers had access to the C, actually that allegation falls off. Why? 14 officers, and we've attached that into the affidavit of Martin Nyaga, including the chairman's PA, Mr. Abdi Daher, who is a registered, who is a returning officer, and 14 other persons were mandated to actually do that verification process on the table. There's a process for them to be given that access, and the access, what access do they have? People are burning up a lot of things, servers and things like that. So there are 3 applications level in any system. You will have the application, you will have the operating system and the network, okay? So everyone has access. So they have access for the verification of the 34C. So they'll be told, we're putting in this polling station to the C, are you okay with it? Does this tally with what is in the original? They will say, yes, that is populated. When we finish for one constituency, we print that aspect of the Form 34C, because Form 34C is something that is gradual. The verified form from the form that has traveled from Kipini in Lamu to the CTC, Constituency Tallying Center, through the portal, physically through Bomas, through the verification desks of the agents and the people complaining here, they are told, are you okay if we put into the sea? It's put into the sea. It's printed out, and that is what was being announced. So if you got the logs for the sea, it will say, the person who's authorized printed out a C, because it was being announced. Some of the commissioners now complaining were announcing those forms, and it's incremental. It will go on until we finish. Now coming back to the form. So the first security feature is, if you look at the portal I've indicated, it has all those. But we put security features to enable the court and everyone to authenticate our forms. If you open our forms in Acrobat Reader, you will get a signature panel. You will get a signature panel. And the signature panel is able to tell you the path of validation of our forms. It will tell you that this form, in fact, the timestamp you'll get on the signature panel is the same as the timestamp when that form was received at the portal. And I've projected, your ladyship, I've projected there. And if you are a good Acrobat, it will tell you, it will give you a signature panel. It will tell you that this form was not first modified. If you have any PDF form document and you have modified, it will tell you this document was modified on this date by XYZ. It will tell you this form has not been modified from that date. It will also give you assigning a signature. You see that time there? That is the time that is on when it was received on the portal. It's the same timestamp that when you open any form on the portal, it will indicate. So the allegation that forms were intercepted, staging happened, the authentication of our forms are very robust. So the second one now. So how is someone able to prove that our forms do not tally with what is in the portal? You only have to do one thing. You have to download our forms from the portal, get a relatively good Photoshop, and change the numbers on the tally. And I'll come to those allegations where the 34A in the portal are the same as what was given to the agents. We have provided 44 affidavits from various POs. Some of our POs who are Kenyans have had a very sleepless nights. Allegations have been made against them that the forms they brought to the ROs were different from what was announced. The allegations of an affidavit made by someone should be checked against the affidavits of each and every polling station clerk and polling presiding officer who we have endeavored to give the affidavits to the court. And we have given 44 affidavits for presiding officers on these allegations, and many more affidavits for the returning officers. So the only way you will be able to show is you have to print out our form. And the problem with that one is because you cannot do anything about this, where the agents and everything sign, you have to get a Photoshop, amend it to JPEG, get a Photoshop, and actually just remove with the tally. But like every other plan, it has a lot of weaknesses. And the first weakness you will get is, and the first thing they say is, in Gaina polling station in Tiati, that their agent provided them a form. And this is really important for the court. We say untruths have only one leg. They don't have two legs to stand on. The truth stands firm. They say in Gaina polling station, and this is in the affidavit of Arnold Ochieng, that their agent provided them a form. The form is different to what is in the portal. If you look at what is in the portal, that is in the affidavit of Moses Sunkuli, and even the form he has attached himself, it says there was no agent in Gaina polling station. We haven't even gone to authentication and the verification of the process and the form, and I will show that why this is a bad Photoshop gone wrong. So the first allegation is, in Gaina polling station, their agent gave them a form. The tally for the presidential candidate is different from that. Guess what? The form they provided does not indicate there was no agent. And even our portal says there was no agent for any candidate, not only for them. In Gaina, there was no agent for, I don't know why the parties didn't send an agent there. maybe because of security in Tiati, or we don't know. But there was no agent for anyone. He says, I had an agent, and this is his tally. So to the question that whether the forms provided by the agents are the same as what is in the portal, the court has to come to one conclusion. Those forms that are being provided in those stations are doctored. They are forgeries, and bad forgeries at that. The first paragraph of that affidavit says so. The other thing you will notice, that what they have attached, we were very deliberate why our KIMS kit will have an imaging software embedded and sent in PDF. One is because of the security I've indicated. The second one is because, since it is black and white, and agents will be taking pictures of the form, we wanted to differentiate between what the agents are taking with their form and what we are sending ourselves. So, what have they done? Our forms have been printed from the portal, converted to JPEG, numbers fudged. But the problem is, all the background for those forms are our KIMS kit. It's what we sent in the portal. And I've indicated that in the affidavit of Moses Sunkuli. The second and the more problematic thing, and analytically the court will ask, is it possible that 44 agents all over Kenya will take pictures of forms in black and white, the same as the background of our KIMS kit? And the reason is because of the robustness of our processes. Because we have a manual check and we also have an electronic check. The manual check I have described, the electronic check, the EVI. The second electronic check, I have described how our forms arrives. So if someone made an allegation that, oh, the form of my agent is different from what I have, the court should ask, okay, we have a portal, we have IEBC POs who are saying something else, we have the original, which has gone different stages. How come it's only your form? And what is fudged, Your Ladyship, I want to point out to the court, is the only thing that has been amended in those forms is the number of tallies. Why have they done that? To tell the court, oh, look, IEBC portal is different from what we have. Okay, if you are thinking, and the challenge that I have been given the challenge that I've been told by my ICT people is we will leave our portal open for another year. If any one of these people who are alleging anything, let them go upload one form. And we took our constitutional duty very seriously to give that audit trail to the court for the court to be able to make a determined decision. I will mention 3 things on ICT. The first one is John Gidongo has given us an affidavit, which we have answered with Martin Nyaga's affidavit. He has given forged logs. And when we actually answered and actually told him these are forged logs from 2017, he said, oh, these are demo, but these are the real ones. But I think the court should look at the real logs. For example, one of the logs that is charged is the one for Justice Nyangaya. Justice Nyangaya attached Linux cron logs. The ladyship, it's like, and he says these people had access. It's easy to read those logs. They did not mention, no one of those people had access. It's like someone telling you, as you are using your computer, it's running background information, it will give a lot of, the OS will be running. It gives a lot of information. And someone says, oh, Emma had accessed the laptop of the judges and did this. And the information that person is giving you is the OS system. Oh, this server, there was an update of this program, there was this. If there was any evidence of that, you should provide something that says, this person accessed at this day on this, at this time. So even the logs which are attached to Jason Nyanga's affidavit are not things that will bear out the allegations they are making. The second thing that I want to mention to the court is the affidavit. A lot of people have made the submissions by the petitioners was that the affidavit of Benson Wesonga and John Njoroge proves there was access. We've answered those affidavits, and you will read it, it will surprise this court, that Njoroge says, I audited the IEBC system. And in answering the first question, we told him, that is a criminal offense. How do you have access to the IEBC system? Which, of course, is a lie. Then he attaches logs. Some of them cooked up, but some of them we've answered. So, for example, he says, the chairman's PA, a gentleman of repute and an advocate of this court who's been a row all over the country, who was part of the 15 people who were doing verification on the bomber's desk, who all the agents were present when they were making the verification of the C. Oh, him he accessed, and 2 other people. How many times? 1,000 times. First, what did they access? I told you, no one can access or upload anything apart from the Kim Sone. What they accessed was at the verification panel for the C, and all the agents were there. Did they require the chairman to sit there entering manually the 46? And in fact, we have attached the authorization for each and every person who was seated on that table. And the court should take judicial notice of what was going on in Bomas and the constitutional timeline relating to the 7th day. Those people had access, the agents were there, everyone was there, and of course, they will verify. He verified 1,000, another person will verify 800. There are Kenyans who have not slept for 5-6 days to actually undertake a constitutional duty of a higher calling. Not well remunerated people who hadn't slept for 6-7 days. They are actually, what they are doing is, they access. Yes, what were they supposed to do? They will access the RTS panel for the C. They will verify you are there. The deponent was on the floor of Bomas. Njoroge was there. Their agents were there. The ICT was there. And the court should make note of, there was no one allegation that a form that is in the portal was different than an original which they had verified as relates to the tally. So there's another argument that they say, our client, the petitioner votes were deducted and added to this. We told them, show us the proof. How are they deducted? We have 7 proofs. So in mathematics, you use proofs to prove a point, to prove knowns and unknowns. We have 7 proofs. We have our arrows at the polling station. They had agents. You had agents at the CTC. We have the original. You have agents at the NTC. We have original. We have what is transmitted in the portal. We have original. All of them tally, and you are saying your client's votes were deducted. How? I will mention a small issue on the register. I want to note the court, we understood the issues as framed by the court as those issues. The issue of the register was not one of the issues. We have answered in the at paragraph 85 of Hussein Marjan and Michael Ohuma's affidavits. We did an audit as per the law. The audit was as required by the law, was transmitted to the Speaker of both houses. We did a resolution of most of those audit processes. We have documented what has been done. 262,000 deceased people were removed. There were some Kenyans who had registered both with their passport and IDs. And that process of audit is an ongoing process. We will endeavor to complete it, but I want to confirm to the court that that audit process undertook, and we acted on that audit process, and we went to with a clean register. With the elections. An allegation was made that, oh, your client was printing 34 A's, many of them to actually do something untoward. We want to tell the court, and we have put before the court, that the reason that was actually done, book 2 of 2 and book 1 of 1, is to ensure that as many Kenyans as possible had copies of the 34A. So you have a form 34A, and if you printed only 6 copies, one copy goes to the ballot box. 1 copy is supposed to be attached to the polling station. Those are 2 copies. 4 copies are supposed to be given to presidential copies to the presidential candidate. Then we have an issue that a copy has to go to the RO. And what we did is we wanted to print many copies of the A's for the purposes of the result. And the reason why, because the carbon copy, if you reach 6 and you are actually writing on the carbon copy that you are giving copies of, when you reach the 3rd copy, it will not even be able to, you will not be able to read it. When that happened, the petitioners, together with religious leaders, traveled to Greece, and they raised an issue. They say they did not want book 2 of 2. So what did we do? We just gave instructions. We had a meeting with them. The same was shared by the chairman. The chairman, the same directive was given to our officers, and when they opened the polling stations, book 2 of 2 was being put in the ballot box. 34 2 of 2. An allegation was made, and this is, I think my ICT people have told me they actually want to buy the patent of this technology, that a JPEG of handwritten document can be converted to CSV, amended, on a form that has signatures and watermark, and converted back to PDF and uploaded. If such technology exists, we actually want to buy its patent. It's actually impossible to do that. And that is why all of the forms that have been submitted, the only thing that can be done is you have to just look at the tally numbers and try to use Photoshop to change the tally numbers. You can't do that, because the verification process has 8 stages. This form is widely available from the village to the NTC, that for someone to say that, oh, my 34A has been tampered with, it's impossibility. To just conclude, the petitioner's case says 500,000 Kenyans who conducted the elections, POs, deputy POs, ROs, and everyone, conspired against them. That is, the numbers don't pan out. The allegations of the form don't pan out. And the question I kept on asking, and this court should ask, is, what if on the day of the election, God forbid, that the RTS system of IEBC collapsed, and the only thing that is available to this court are original Form 34As? Will this court say, since your RTS system collapsed, there's no election that you held, that the franchise and the vote of the Kenyan cannot be gotten from those ballot boxes and those forms? And the second question, and which is really, and we have indicated that in the firewalls and the affidavit of Hila Kavogo, and how robust our system was, and how many, who tried to do that. The other question is, 300 million Kenyans access that portal. They know the results as indicated. Those results can be verified from the forms originally available, from the forms of the agent. And I think the court should make a determination that their numbers don't add up. The allegations of the form fall flat on what we have demonstrated. And the allegations relating to forms in the portal being different from what their agents have are an attempt to actually present the court with evidence that it forged. And the court should actually look at those documents, look at those forged logs, and take necessary action against any officer who will have presented those logs or documents. Allegations have been made about Gudino and access. You will find in the affidavit of Hila Kavogo, those people were leads who were actually providing ICT help at the level of the systems. Every person was logged off from our system on the 8th of August. There is an email we have attached to the affidavit as relates to that. Anyone who had access to our systems was someone who was authorized to do. And finally, the court should ask the question, whether the 50% plus 1 was met. And to that question, Your Ladyship, the late Justice Antonin Scalia, whenever he went to give lectures to all over the United States, everyone used to ask him about Bush v. Gore, and he will know whether someone is a Republican or a Democrat as to the question they will ask, and his answer will be, get over it, it's over. So to 50 plus 1, the court made its determination in 2013 on the votes cast and valid votes and the rejected ballots. Rejected are not votes. Votes is an authentication of preference. There's nothing called rejected votes. That's a rejected ballot. The court emphatically made that decision in 2013 and in 2017. To the petitioner's answer as to that, I think the simple answer will be, get over it. With those few remarks, I yield the floor.
Thank you very much, my colleague, Mr. Mahat. Madam Chief Justice, Madam Deputy Chief Justice, honorable members of the court, may it please you, I am called upon to look at issues number 8 and 9 on the materiality question and on reliefs. My Lord, in view of the time, I will not go into...
Sorry, Counsel, for our recording system, if you can just introduce yourself. We know you, but for our...
I apologize, my Lord. My name is Abdi Kadir H. Mohammed. I appear with my learned colleagues for the IEBC and the chair. My lords, my ladies, in view of the timing, I will not go into a lot of the law as far as the standard of proof is concerned. This matter is tried as far as the law is concerned. The standard is higher than 4 civil cases, normal civil cases, but does not go as far as required for criminal cases. In other words, it does not go as far as beyond reasonable doubt, but it is higher than a balance of probabilities, except where criminal conduct is alleged or there is an election offense alleged, in which case then you go to the higher proof beyond reasonable doubt. The submissions of the first and second respondent in the lead, the submission of the respondents in the lead petition at paragraph 8 Page 4 deal with the law, the cases, Raila Odinga 2013, para 203, number 1, presidential election number 1 of 2017, para 151 to 152, and the courts clearly state that the allegations should not be general, they should not be bare allegations, and the standards must be met. In John Harun Mwau, at page 349 to 350, 2017, that was the holding of the courts. So the law is very clear on this matter, my lords and my ladies. I'll then go on itemizing some of the allegations or some of the issues raised in terms of illegalities and irregularities, and specifically state whether those standards have been met, and in broad case, they haven't. So there have been allegations of a dysfunctional commission. This, my lords, is not a court dealing with a corporate governance case. It is an election petition court dealing with the presidential elections in 2022. My lords and my ladies, the case of Maina Kiai dealt with the issues of the commission and the chair and their place in the process that we're talking about, in the verification process. And it's very important to understand that the petitioners want to turn that case on its head, because if you recall, what the petitioners in the Maina Kiai case were fighting against, it was the interference by the commission or the chairman in the results when they come to the National Tallying Center. This is exactly what the petitioners are asking to do. They are asking the commission to interfere with the results at that point. That is not the law. Number 2, there was the allegation that the commission is equal to the commissioners. That was dealt with by my learned colleague, Senior Counsel Kamau Karori. But let me just add that it will be absurd to say that the only elections, the only verification that is acceptable under the law is verification by the commissioners. What then would we make of the elections at the counties and the tallying and verification at the counties and the tallying and verification at the constituencies where no commissioner is present? What would we make of section 39(1)(c), which says the commission will transmit? Which commissioner transmitted when? It is the commission officers, the commission employees, and the commission is certainly more than the commissioners. My lords, that allegation, therefore, that there was a dysfunctional commission and this led to the results not being verified is not borne. The standards have not met, and it is not the law. The commission practically will need to rely on its officers across the country in the 46,000 plus polling stations for the work of the commission, including presiding officers verifying and transmitting. The next allegation broadly was the issue of the rogue chairman. Here we have a bogeyman where all the issues can be affixed to this good gentleman. At the end of the day, after you clear through the fog, what were the issues that the chairman was being accused of? They do not meet the standards, I pray, that would be required for us to overturn the presidential elections in the general election of 2022 and send 14 million plus Kenyan voters back to the vote and spend immeasurable amounts in treasure. The chairman is accused of single-handedly conducting the elections, of gazetting himself, and it's alleged that the office of returning officer for the presidential election does not exist. I adopt the presentation from my learned colleague, Mr. Kamau Karori. But suffice it to say that we all accept that 138.10 gives a role to the chairman to declare. That regulation 87.3 gives legal roles to the chairman, and case law has given legal roles to the chairman. Those roles, when you put them together, essentially spell out the role of a returning officer. And In the old company law, the definition of a director used to go that a director is a director by whatever name called. And the returning officer is the returning officer by whatever name called, because he is undertaking the functions of the returning officer. Let me now turn to the allegations from the other commissioners and the averments in the affidavits. If you look at the totality, what you get is that these good ladies and gentlemen were either negligent or unaware of their functions, or in fact were not stating the truth as such, because the law requires for the commission to hold a minimum of 1 meeting per month. More were held during the elections. They attended all those meetings under the affidavits. The vice chair and Mr. Wanderi attended the trip you were told about in Greece, where they went to check on the presidential ballots. The announcements were made by these good people almost 70% of the time. In other words, almost 70% of the announcements done at Bomas were done by these particular commissioners. And the tables were there for everybody to see where verification was happening. And they had no one stopping them from going to attend or direct if they wanted to direct. We would have shown at this point their access to the floor in the 4-minute clip, but in view of time, I will skip that. But I would urge the court to look at that video clip to show the extent of the operations of the commissioners, especially these 4, in terms of the operations at Bomas. Then we go to the 27 constituencies. The affidavits clearly show that those constituencies were tallied and they were in fact verified, and that the record will clearly show that what was remaining was the announcement. And the 4-second clip will show you the environment and the fracas at the announcement podium at the point in time when Professor Gulie was to go to that podium to announce the 27 stations which had been verified and tallied. I'll play the 4-second clip. Thank you, Sonia. Please. Yes, this is Bomas just before Professor Gulie was to announce. This is covered in the affidavit of the chairman, and is also touched on in the affidavit of Professor Gulie and also the chief executive, Mr. Marjan. My lords, that was the environment at that particular time. It was practically not possible for Mr. Gulie to announce. Our contention is that lack of announcement does not go to the level where you would consider those constituencies untallied or unverified. What then were the aim of the commissioners when they say we wanted to, quote unquote, own the results? Because verification is a very simple process. It has been defined. I'm not going to waste a lot of time on it. Tallying is a mathematical process. The only other verification required, other than compare the forms, was has the candidate met the 50% plus 1. What the commissioners actually wanted to do was what was stated in the affidavits of the chairman, the Professor Gulie, and Mr. Molu, which was to moderate the results so that a pre-agreed or pre-arranged result can be declared. That is what they wanted. What they wanted was for a meeting to sit over the decision of who will be president, not the voters, not Form 34A, not the polling station as the law is, but for a meeting of the commissioners at the National Tallying Center after the work had been done to moderate. That is illegal, it is unconstitutional, it is completely unacceptable. And this is in the affidavits. There were 2 meetings prior to that final meeting. One where there were visitors from the security agencies and the other from individual Kenyans. And those meetings were confirmed by all the protagonists. And this really was the scheme. This was the rupture. You asked yesterday, how come we had not heard of this dysfunctional commission earlier? Because it was a process that was going on, and at the point of disagreement is at the point where now we have rupture. And from that point onwards, those commissioners are part of the scheme, and this time, instead of announcing the wrong results, it is aimed at getting this court to overturn the results. That is the scheme. That is the decision the commissioners wanted to be part of. In terms of technology, there are a number of allegations. I adopt the presentation from my colleague, Mr. Gumbo. In terms of the numbers, I adopt the long presentation of Mr. Mahat. And I would stop there in terms of the allegations. Suffice it to say that there have been many, they have been sensational, they have remained unproven, and they are not worthy of the level required to overturn the presidential elections of this country. Let me now go to the remedies very briefly. And the remedies, just one point in terms of the earlier issue. There was a push for moderation. That essentially is to overturn the elections. There was interference from state agents, again asking for a specific. Those are averred in several affidavits. There was the issue of the DCI and certain other state agencies. Contrary to the law requires that under Section 105 of the Elections Act, that all state organs and state officers must give assistance to this commission during this difficult period. Contrary to that, the DCI was indeed an impediment to the holding of the elections and to the functions of the IEBC at that point in time. There were very many officers of the commission picked from the tallying center, outside the tallying center. It is not a coincidence that the 4 commissioners refer to those staff members which were then picked by the ATPU. Ask yourself, what is the anti-terrorism police unit got to do with our elections in Bomas? Why would the anti-terrorism police unit be involved in the tabulation verification exercise at Bomas? And that scheme, that assault on our democracy is what you are being asked now at the tail end to. Let me also refer you to the affidavits of the commissioners where they say that the election process was okay until the very tail end. That tail end is where the matters went haywire. Let me go to the reliefs, my lords and my ladies. The reliefs as known by law in terms of the Constitution is at 143. The Supreme Court, if the Supreme Court determines that the election of the president-elect is to be invalid, a fresh election shall be held within 60 days after the determination. And Rule 22 of this court's presidential election petition rules empowers the court, after hearing a presidential election petition, to either dismiss the petition, which is what we are urging the court to do, what our clients are urging the court to do, or to declare the election of the president-elect either valid or invalid, and invalidate the declaration made by the commission under Article 139(5), and then orders to payments. There was a reference to Section 80 of the Elections Act, and it states that the court has additional power to, quote, direct the commission to issue a certificate of election of a president if upon recount of the ballots cast, the winner is apparent and that the winner is not found to have committed an election offense. Our view is that this is not operative in this case. Number one, this section assumes a recount. We have no recount in this case. Number two, it's not specific to the presidential elections, as is the case with the Constitution. And number three, it says that as a precondition, as a condition precedent, whoever is getting the benefit of that relief must, of necessity, have not committed an election offense, which presupposes that there is a process for that to have been determined, which has not happened in this case. In any event, it is the contention of the petitioners that indeed the petitioners or their agents are guilty of presidential or of election offenses, and therefore they ought not to be entitled to that relief. But can I go back to the relief sought by the petitioners, especially in 005? They are very convoluted. There are many. They are conflicting. If you look at, and some of them are strange. For example, there is in paragraph 18 of the remedies sought in the petition number 005, you are asked to uphold the decision of the 4 commissioners in rejecting the declaration. No such decision or no such lawful decision exists. You are asked in paragraph 9 to order directing IEBC to tally and verify, then declare. That has already happened. The tallying and verification has already happened. You are also asked to find that the elections were held in complete contravention of the Constitution, yet declare under section, hopefully 84, the petitioners, the president-elect and the deputy president-elect. Those two do not help the same. And then you are also asked to get the election invalid, in which case the section kicks in that there will be a rerun in 60 days, yet to hold that the IEBC, as currently constituted, cannot hold the election, in which case, again, you have a conflict that is not subject to be determined. So our view is that the totality of the relief sought raise a lot of problems, as mentioned by the judges on a number of occasions. In terms of the reliefs we are seeking the reliefs as listed out in the responses, all of them, and jointly. We are also seeking reliefs as far as the chairman is concerned, as far as the number of criminal actions stated or alleged in the respondents. I adopt all the affidavits, my lords and my ladies, stated by my learned senior Professor Gideon Mugai, and the presentations thereafter. Suffice it to say that what we have witnessed is at the tail end of a very long process. We in this country have gone through a lot of reforms as a result of elections. If you recall, the entire ECK was disbanded by legal fiat as a result of an election. Thereafter, we have had to completely redo our election infrastructure. We have come to the point where this court 5 years ago laid the law. Now, if you look at all those steps, we have taken radical steps that have cost treasure, that have cost lives, that has cost livelihoods, including staff members of the ECK who have either died in office or who have been fired as a result of being told you have all been disbanded. Our law has no problem, my lords. Our elections have no problem. The problem lies with our politics, and the problem lies with our political culture. That cannot be legislated. It cannot be delivered through litigation. It has to be elsewhere. Men and women who run for office in this country must accept that it is possible to win. Indeed, it is even more likely to lose, because typically an election involves more than 2 people, and the chances of the losers being more than the winner are very high. Until we accept that, we are going to be harming the country, we are going to be harming our institutions, we are going to be hurting independent institutions and individuals who work in those institutions. Kenyans who give a lot, ask for nothing, and get to be denigrated in the hallowed halls of this court. My lords, I will stop there. I will ask my... Thank you, my lords and my ladies.
My lady, learned members of the court, it gives me great pleasure to return back to the court 13 minutes and 20 seconds. Thank you very much.
Thank you very much for donating to us 13 minutes. We will Yes. We would like to break now and resume exactly at 2 when we will start now the case for should be yes. Yes. I'm trying to get the right description of the parties, but it will be the case of William Ruto and also the Attorney General. Not now, when we resume at 2, because we haven't risen, we need to rise.
I think in order it will be the 2 commissioners. There are 2 commissioners.
Their case has been done.
You are done?
Yes.
Then it's Attorney General, because
Yes.
we have to respond to the Attorney General, pursuant to the leave you gave us,
Yes.
that we respond to the Attorney General. So it will be Attorney General. My learned senior, Oraro Senior Counsel is present, and then I'll take over the case for the first and second.
There is no problem.
Thank you so much.
Yes, so we resume at 2. Thank you.